Good afternoon. My name is Steve Roth, Chair of Sutherland's Financial Services Practice, and I'd like to welcome you this afternoon to the Sutherland webinar, For Whom the Ring Tones, TCPA Litigation and the Insurance Industry, which is hosted by Sutherland attorneys Lou Wiener and Wilson Barmeyer. This is the latest in our series of webinars devoted to issues faced by the insurance and financial services industries. If you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Should you have any questions during the webinar, please submit them via the Ask the Question text box on your viewing console. The Telephone Consumer Protection Act, commonly referred to as the TCPA, restricts telemarketing and limits the use of automatic dialing systems, pre-recorded voice messages, text messages, and faxes. New TCPA regulations, introduced in October of 2013, specifically require that telemarketers obtain written consent before sending texts or making automated calls to consumers' cell phone or landlines. In today's webinar, our speakers are going to discuss emerging trends such as the recent restrictions applying to any insurance companies that use an automated telephone dialing system to communicate with their customers and other hot issues affecting insurers under the TCPA. Over the past 18 months, TCPA cases are the second most filed type of case in federal courts nationwide, second only to wage and hour cases. Over that same time, we have seen record-setting settlements in these cases, $24 million in 2013, rising to over $75 million earlier this year. Certain industry segments have been targeted by TCPA plaintiffs' counsel, including specifically the insurance industry. Unique issues affect the insurance industry in TCPA cases. As we're going to hear, cases have been filed against insurance companies based on their own conduct. Insurance companies are also involved in TCPA cases on coverage issues based on the conduct of their insureds. Today's webinar is going to be led by my partner, Louis Wiener. Lou has over 27 years of experience as a litigator. Prior to joining Sutherland, Lou was a federal prosecutor with the U.S. Department of Justice, where he, among other things, defended the largest class action ever filed against the U.S. Lou chairs Sutherland's Financial Services Litigation Group, as well as its TCPA subgroup, and Lou is also a member of the firm's executive committee. Joining Lou is Wilson Barmeyer, a senior associate who focuses his practice on insurance litigation and related matters. So with that brief introduction, I'm going to turn you over to Lou Wiener.
Thanks, Steve. Good afternoon, everyone. On behalf of my colleague Wilson Barmeyer and I, we are pleased to present today's webinar on TCPA litigation in the insurance industry. As you'll see from the outline on the screen, we are going to cover certain distinct issues today. After a brief introduction to set the stage and give those who may not be as familiar with the TCPA some background and understanding of the origins of the Act, we're going to turn specifically to the issues that affect the insurance industry. As a firm, we track all TCPA cases that are filed nationwide. From that analysis, we have been able to discern certain trends that affect specific industry segments, again, including the insurance industry. Among the issues that specifically affect the insurance industry and that give rise to TCPA cases are issues involving vicarious liability, consent, and coverage. After discussing those issues, we're going to turn specifically to issues involving litigation risk, and then we'll conclude with some contact information should you want to follow up. As Steve mentioned in his introduction, should you have any questions during the course of today's webinar, we encourage you to write in, and we will answer the questions as appropriate depending on where we are in the segment. Wilson?
Lou, thank you for the introduction and the brief outline. One thing that I think can be helpful in thinking about all these issues and giving some context is to look back in time and see where this Act came from, and that puts a gloss on the statute, rules and the way this area has exploded into some litigation. Lou, can you take us back in time?
Yeah, for those who may not be as familiar with the TCPA as others, the TCPA, Telephone Consumer Protection Act, was enacted over 20 years ago in the early 1990s, specifically to deal with the issue of robocalls, and even more particularly, the issue of marketing calls. We can all remember sitting at the dinner table, the phone rings, telemarketer. The early 90s saw a great jump in the proliferation of cell phones. We can remember back over 20 years ago what cell phones were like. They certainly weren't today's conveniences of being, clipped to a belt. Instead, it was bag phones. It was dedicated car phones, hardwired to your car. We then moved to a great era of portability with the brick phone. But this is what cell phone communication was like over 20 years ago. I can remember debating whether I wanted a service plan of 30 minutes a month or 60 minutes a month because I couldn't imagine that I would spend over the course of a month more than 30 or 60 minutes on a phone. Again, cell phone communication 20 years ago, over 20 years ago, is a lot different than what it is today. So at the time, the thought was, Congress's thought was, they needed to regulate the type of communication that was going to cell phones, the types of communication that was interrupting people's lives. Specifically with respect to cell phones, the thought was every time someone called, they were spending your money. Cell phone plans were expensive, so that 60-minute-a-month plan may have cost you as much as $1 a minute. And if someone is placing an unsolicited call, a marketing call, to your cell phone, they were spending your money. And the TCPA was designed to restrict other people's ability to spend your money using your cell phone minutes. What else did the TCPA cover at the time? It covered, again, it prohibited the use of auto dialers. It created the National Do Not Call Registry. It prohibited the use of unsolicited faxes as a means of marketing. More recently, it's been focused on the use of text as a means of communicating. And it's important to understand as we think about the TCPA, its evolution and the evolution of cell phone and other remote types of communications, to understand that last year, for the first time, over 50% of Americans, more than half of the Americans now, use cell phones as their principal means of phone communication. People are no longer, or are less now, relying on dedicated landlines than they are on cell phones as a means of telephone communication. What does that mean? It means that more people are getting texts. It means that there is greater risk to companies that communicate with their customers by phone, because often what we're finding and what we're hearing and what we're seeing in the complaints that are being filed are that companies are communicating with people not even recognizing that they're communicating with them via cell phone. Why that is important, as we'll see next, is the rules under the TCPA for what you can do with respect to communicating with people via landlines is different than what you can do when you're communicating with your customers via cell phones. The consent is different, and the nature of the communication and liability is different.
We are almost exactly 1 year from the FCC putting in place new rules that change the standard for consent needed to make calls to cell phones. We put up on the screen here a color-coded chart that reflects that there are a lot of different rules that apply based on whether the call is to a cell phone or to a landline, whether the call is for telemarketing purposes or for non-telemarketing purposes, just an informational communication. The rules depend on whether it's a call made with an automatic dialer or whether it's a pre-recorded voice call or whether it's a call that an actual human being is making on an individual one-off basis.
And we've developed this chart, and it's available online on our firm's website under our TCPA web page. And again, it's intended to be very simple: green, yellow, red. Green is go, yellow is stop, red is hold it. Don't undertake this action unless you do what you're required to do in terms of obtaining some form of consent.
The biggest change that the FCC rules put in place was that they changed the standard for making telemarketing calls to cell phones using an automated telephone dialing system, or an auto dialer. For telemarketing calls, the FCC now requires that companies have prior express written consent. And we're going to talk specifically about that standard a bit later, but the key point for purposes of this chart is that the consent has to be in writing, and the company has to retain a record of it. The older standard still applies for non-telemarketing calls. Still have to have consent, but that consent can come through a non-written form. It could simply be the person providing their cell phone number to you, or the consent could be oral. The new rules and just the TCPA rules generally are much more focused on cell phones than on landlines. For informational calls, non-telemarketing to landlines, the TCPA generally does not cover those calls. On the telemarketing side, there is the do not call list if you're making marketing calls to landlines, but some of the more restricted cell phone provisions don't apply. There is, you can see, a red box towards the bottom right. The highest consent standard does now apply to telemarketing calls to landlines using a pre-recorded voice message. So that is one area for landlines where you have to be particularly careful. Another thing about the new rules, not on this chart, but I think it's important to mention, is that the new rules did away with the prior relationship exception to some of these boxes, whereas before, if you were making a call to a landline with a pre-recorded voice, you could do that call if you had a prior business relationship with a customer. No more. Now you need to have the prior express written consent. Also not on this particular chart, but I think worth mentioning, is that the FCC rules and the statute also apply to fax communications, and there have been a number of cases brought against insurance companies for sending unsolicited fax advertisements. So that's another area where if you're sending a fax solicitation, you're going to need to have consent from the recipient, and there's different ways that that consent can be obtained.
With that as backdrop, let's talk about the specific issues affecting the insurance industry, and specifically the causes of action that we've seen primarily raised over the last 12 to 18 months in cases affecting the insurance industry. First among them is vicarious liability, the actions of third parties that implicate the insurance companies and give rise to liability.
This is a really important area for insurance companies, and an area that we've seen come up in almost every case against an insurance company directly. And that's because usually it's not the home office that's going to be sending out pre-recorded advertisements or text messages out to potential customers. Usually it's going to be an agent, and the home office's relationship with that agent may vary. It could be a semi-autonomous or an independent agency that's making these communications. And so where the communications are not coming from the insurer's home office, there's a lot of agents out there that can undertake their own mini marketing campaigns and not follow the rules. We see this issue also comes up, for example, in cases against restaurants, where you might have a home office business restaurant chain, but then its individual franchisees may be undertaking some of their own marketing efforts. Then to make the chain even longer, it may not be the agents themselves that are sending out the communications. It could be the agent has contracted with a third-party marketer or vendor to assist them in sending the communications. Or even it could be the agency is working with a consultant, and then the consultant is working with a vendor. So there can be quite a number of parties involved in sending out these communications before we get back to the home office and what was the involvement of the company.
I guess the overriding theme here, and we'll see this throughout, is it's important to know what's going on in the field. It's important that people understand what their agents are doing, what even their independent contractors are doing. And what we have seen, for example, there was one case that we defended, a putative class action that was filed. The people at the home office really had no idea what was taking place in the field. And yet what was taking place in the field is what created the liability for the parent company. You had people using auto dialers, people using predictive dialers. They weren't getting consent. They were, to a large degree, they didn't know they were required to. We dealt with the litigation, but we also dealt with the issue of having the company educate its agents as to what was required, so they weren't either intentionally or unintentionally creating liability for the parent company. Someone's asked the question of what's the difference between an auto dialer and a predictive dialer. We have a legal alert out on this issue of what is an auto dialer, and there is some dispute among the courts as to what specifically constitutes an auto dialer. But basically, an auto dialer is any piece of hardware or software that has the capability to dial pre-submitted numbers. So you could submit some form of spreadsheet that has 10,000 numbers, and at a press of a button, it will simply go down the line and dial the next number. The predictive dialers are somewhat different in that the predictive dialers do not necessarily rely on a pre-submitted list, but can generate calls to any number of telephone numbers in a specific area using certain criteria. There are very sophisticated algorithms that go into the programming of predictive dialers, but they, to a large part, get you to the same place in terms of liability as to whether you're using an auto dialer or a predictive dialer. We live in an era of technology where some could argue that your iPhone constitutes an auto dialer because of the manner in which it can dial numbers. Clearly, in my opinion, the Congress did not intend Apple iPhones to be within the ambit of the type of equipment that could give rise to liability under the TCPA. I think that's why we're seeing more of a departure in the courts in terms of them not being in agreement as to what constitutes auto dialers.
One of the key auto dialer issues is whether the hardware and software actually has the capacity to randomly generate numbers, or whether merely storing and calling from a list is sufficient. Back to the vicarious liability issue, the FCC in a 2013 ruling declared that there can be vicarious liability under the TCPA under a broad range of agency principles and incorporated federal common law of agency. So whereas formal agency, apparent authority, ratification. So whereas there is direct liability against the party who is actually initiating any communications, this vicarious liability standard may apply against other parties in the marketing chain.
Wilson, I guess it's true in this sense that we are our brother's keeper when it comes to vicarious liability in the TCPA.
Absolutely, and let's look at a few examples of that. A recent case against 3 property and casualty insurers, there was a recent decision on a motion to dismiss that got some press about 2 months ago. This case involved a lead-generating marketing company, and they were making pre-recorded calls to possible insurers saying, save on car insurance. If they got an answer or had a call back, then the lead generator would refer sales leads back to agents of 3 insurers. And the plaintiffs brought a class action against all the parties in the chain, including the 3 insurers themselves. And the court initially said, well, there can be no direct liability against the insurers because they didn't initiate the calls. The insurers moved to dismiss and said, well, there can't be vicarious liability against us either because we are too removed from the chain. And the court granted the motion with respect to 2 companies, but denied the motion to dismiss as a 3rd company and said that vicarious liability had been adequately alleged. The court, it was a very fact-specific decision. The allegations were that the agents had directed the quality, timing, and volume of the communications, that the agents, the insurance company's agents, had been involved in the targeting of the calls. And so the court found that there was an agency connection between the lead generator and the insurance agency. And then on a sub-agency theory, the court looked at the relationship between the agents and the home office insurance company and said that an agency relationship was plausibly alleged because there were allegations that the insurer had recommended this lead generating service and had given some instructions to the agents to market in this way. So that case is continuing against one insurance company, and I think it gives a good discussion of these issues, and you can see the contrast between what facts were alleged and what facts were not against the other 2 companies. We have seen in some later filings in putative class actions against insurance companies, plaintiffs' counsel have read this decision and are sort of incorporating the themes of this case into their pleadings to try to survive a motion to dismiss in future cases. There have been a couple of significant recent cases on vicarious liability, not involving insurers, but helping to set the standard for vicarious liability in these TCPA cases. And these are a couple of quick examples that we'll give so you can see how these relationships may play in some of the issues that you may be dealing with.
I think it's important to note that while these cases don't involve insurance companies per se, what we've noted over the last 12, 18 months is that there is a very small group of frequent flyer plaintiffs' counsel that are filing the vast majority of these cases. And they're using the theories in one type of case and applying it to the other. So again, while the Gomez case doesn't talk specifically about insurance company liability, we'd be very surprised if we don't start to see these same principles, now that they've been successful in one area, applied to another.
Yeah, in this case, we had 3 parties in the chain. The underlying communications were text messages for purposes of U.S. Navy recruiting. The Navy had hired a consultant. The consultant had hired a vendor who actually sent the text messages. The consultant was the defendant in this case, the key defendant in this case. And the consultant tried to say that because they were in the middle of the chain, they couldn't be reached as either a direct or vicarious liability participant. They said, well, we didn't directly send the messages. The vendor sent the messages, so we're not directly liable. And the consultant said, well, the messages themselves were sent on behalf of the Navy, so we can't be brought into this on a vicarious liability theory either. The Ninth Circuit said that vicarious liability, federal common law applies, and that if there is agency relationship, all parties in the marketing chain are potentially subject to suit. So a decision by the lower court dismissing the claims against the consultant was reversed and remanded. Another recent case that came out differently involved 4 parties in the chain. There was Taco Bell was the parent company here. There were several franchisees in the Chicago area that were undertaking a marketing campaign. Those franchisees hired an advertising firm. The advertising firm hired a vendor. Taco Bell succeeded in getting out of the case. The court held that there was no evidence that Taco Bell had authorized, controlled, or ratified the messaging campaign, and where they, quote, had nothing to do with the messages, there could not be vicarious liability back against the parent company.
The important takeaway on the vicarious liability is know what your people are doing. Know what's happening in the field. Know if your name is going out. Again, keep tabs on that, and be sure that your people are educated as to the contours of the TCPA and the potential liability attendant to it.
Another big topic, moving out of the vicarious liability area, another topic that comes up in virtually all of these cases and has come up in a number of the cases filed against insurance companies is the issue of consent. Lou, can you talk to us a bit about the difference between telemarketing and non-marketing?
Consent issues are really at the epicenter of a lot of these TCPA cases. Did your customer authorize the type of communication that he or she is receiving? And the type of consent that is required, excuse me, depends on the type of activity that underlies the communication. And the initial question that has to be asked is it telemarketing or is it not telemarketing? What is telemarketing? Telemarketing in its purest sense is an ad. It's a communication to encourage the purchase, the rental, investment in property, goods, services. Is it something that asks you to spend money in some form? It's advertising.
There was one recent case against a life insurance company where the life insurance company prevailed in getting the case dismissed because the key issue was whether recruiting communications were telemarketing or non-telemarketing. The communications were inviting the recipients of the calls to attend a recruiting seminar to become insurance agents. And the plaintiffs argued, well, that's part of the whole marketing process. And the insurance company prevailed in that case on an argument that that's not telemarketing because recruiting is not marketing.
Right. The rules that apply to telemarketing and the type of consent is the most stringent form of consent. In order to send advertising, telemarketing to individuals, you have to have prior express written consent. And the focus is on written. It must be written. It must be signed. In that regard, e-signing is okay. It has to have the phone number that you're authorized to call. It must specifically authorize auto-dialed calls. And you cannot make the provision of the consent a condition of purchase.
Here, given that there are 5 very specific elements required for telemarketing, getting this written consent, this is not the type of consent that a company is going to get without planning for it in advance.
That's correct.
We're working with a company right now that wants to start up a text marketing campaign. And at the outset of their project, how many consents are they going to have that are going to meet this standard? 0. The level of specificity required for this consent is going to require you to specifically get these consents before you can market.
That's right.
And so planning in advance is very important on this.
And it's important to note, and it was said in the outset, in October of 2013, just about 1 year ago, the FCC changed the rules. It used to be that prior express consent was all that was required. Now for telemarketing, it has to be written. We're working with a number of companies that now have to go back and get that written consent. There was nothing in the statute or the rules when they were revised that provided any type of grandfathering. Several comments were submitted to the FCC asking them whether they intended there to be grandfathering, and to a large degree those have gone unanswered. We've seen a good number of lawsuits that have been filed against entities for not having written consent based on their communications post-October 2013. Based upon the lawsuits that we've seen, the decisions from the courts, we have advised our clients that they need to go and get that written consent from their existing customers. The risks, if they don't, is that they will be deemed to have violated the TCPA for those post-October 2013 communications. So we have telemarketing on one side, and then we have non-telemarketing, non-marketing on the other. What's non-marketing? Well, it's the type of your premium is due, your policy may lapse, confirmation of receipt. Debt collection is not marketing. Purely informational messages fall into that category of non-marketing, something that does not require the expenditure of funds for a product.
Many of our insurance clients send these types of messages through the mail, and expect that to continue. But we also, in the modern world, are seeing a proliferation of electronic communications, and so these issues may become increasingly important. One important thing to note here is that a dual-purpose call is marketing. So if something is 90% informational and 10% marketing, it's going to fall under the marketing rules.
Someone's asked the question, does the express consent apply to the sender, or can be something along the lines of, I authorize you and your marketing partners to call me at this number? Again, it's important to understand that for non-marketing, non-advertising, the standard is express consent. And let's go to that next slide, because I think that illustrates it. Again, express consent is simply providing a phone number in connection with a transaction. The logic is simple. If you didn't want me to call you, you wouldn't have given me the phone number. That's express consent. The question, though, asks, can you have express consent where you simply give someone blanket authorization to call you? And again, it depends on whether the purpose of the call is for marketing or non-marketing. I struggle with this idea of what is express written. It's either written or it's not. And the standard is, if you're going to communicate with someone for marketing purposes, the consent needs to be in writing. That consent can be blanket consent. You can say, you give me consent, you hereby consent for this entity, my marketing partners, to contact you for marketing purposes or for any and all marketing purposes. That, I think, is sufficient consent. It just needs to be in writing, and it needs to be signed.
Can you get consent for your agents to contact them? Yes, you can. The consent could say, I authorize company A and agents sending communications on their behalf. I think that is a sufficient consent under the FCC, and we see a lot of our clients getting those types of consent.
So again, the type of consent, whether it's marketing or non-marketing, is different. The marketing requires written consent. The non-marketing simply requires express consent. And again, the express consent is seen, and courts will deem merely the provision of a cell phone number or a phone number as satisfying the express consent condition.
Lou, talk us through some of the other issues that come up around consent, because there are a number of them. We don't have time to touch on them all today, but let's look at a few.
Well, we've seen cases where the called party was not the intended recipient. You see that come up in the case that I'm thinking of. It was a reassigned number. Person A had a cell phone number that they relinquished. They went to a different carrier and elected not to keep the same cell phone number. In relatively short order, within several months or so, the original carrier reassigned that phone number. The company in question, who had been soliciting for agents, called the number that they had been provided on a resume. They had every reason to believe it was Joe Smith. Joe Smith had submitted his online resume. They called the number on Joe Smith's resume, only to get Bob Jones. What does Bob Jones do? He sues them for violating the TCPA, saying, I never authorized you to call me at this number. What was the company's defense? We had a good faith belief we were calling Joe Smith. But the courts have concluded that consent runs with the person, not with the number. And because of that, the consent to call Joe Smith was unassailable. They had every right to call him, but he no longer owned the number. And the burden then shifted to the company to know who they were calling. And the liability attached under the TCPA, because even though they had a resume from Joe Smith, they called Bob Jones. You see, there was another case more recently out of Florida where a spouse provided her husband's cell phone number. And the consent ran with the person. The idea being that the allegation was that he hadn't given consent. The court then went back to the parties and said, if the company can show that there was a relationship there such that she had authority to provide his cell phone number, then there would be no liability under the TCPA. But the important thing to remember about this is that the consent runs with the person and not with the number.
Lou, what about the scope of consent? If I give my phone number to an insurance company for one purpose, say I'm changing my address and I provide them with my updated information, I give them my phone number, what's the scope of my consent?
This has been the subject of a great deal of litigation over the last several years. Again, as Wilson said, you give your consent for a specific purpose, but that then leads to communication in another area. What courts have said generally is that consent is only for a specific purpose. But I'll give you an example. In another recent case, a cell phone number was given to a medical provider for a patient that was going in for necessary treatment. The patient didn't pay their bill. The matter was turned over to a bill collector, and the debt collector then contacted the individual at his cell phone number. The individual then sued under the TCPA saying, I never gave consent to be contacted for purposes of bill collection. I only gave my consent for purposes of receiving medical treatment. The case actually was decided initially in the patient's favor. The court concluded that they had only given consent for a limited purpose, but the appellate court reversed, holding that the collection of the bill for the provision of medical services fell within the ambit of the consent necessary to contact the patient. So you're seeing these scope issues playing out. Generally, and again, as the question earlier asked, can you get blanket consent? And the answer is yes. And we are encouraging our clients to write the consent provisions in a way that would cover the type of scenario that we're talking about here, where you provide the services, they don't pay the bill, you then refer the matter for debt collection, that all fall within the scope of the consent.
Revocation of consent, another issue that can come up, and we've seen a number of lawsuits where this is a possible fact pattern.
Now, Wilson, there is nothing in the statute that talks specifically about revocation of consent, is there?
Well, there is for some types of communications.
Right.
Under the new FCC rules, for marketing calls, for text messages, you have to have an opt-out notice within the call, so that if the consumer is receiving a marketing text message, there needs to be something that says, if to opt out of receiving future messages, text this number, so that they have an opt-out in front of them. Fax solicitations have to include an opt-out right on every fax, and there's very specific rules as to what that opt-out needs to say. So if you have an agent sending fax messages, you check very closely to make sure that that fax opt-out meets the standards for faxes. For informational messages, there is no explicit opt-out right, but there is certainly a case law trend. A number of appellate courts have recently held that consumers can opt out, so that if they give their consent by providing their cell phone number, that consent is not not eternal. Moving on, insurance companies can get involved in these cases in a number of ways, and we've talked about some issues that can specifically affect insurance companies who are sued directly. But insurers also can get brought into these cases on coverage issues. Lou, can you talk to us a bit about insurance coverage and how these cases work?
Thanks, Wilson. The most common type of issue that we're seeing in the coverage cases are where there's been an exclusion under the policy. More and more companies are writing policies with specific TCPA exclusions. Those are the easy ones. We are seeing other cases where there may be a general exclusion, for example, for punitive damages. And the cases, the courts have said, in fact, there was a very recent case out of Illinois that said damages under the TCPA do not constitute punitive damages and may be insurable. So you do have the more common policy exclusions, advertising liability, exclusions for violation of statutes or regulation, and again, as we mentioned, specific TCPA exclusions. Just going back to that, again, it is important to understand the contours of the general policy exclusions under contracts and as they're construed by state law, because these are largely, if not exclusively, state law animals. And the extent to which different courts recognize the validity of different exclusions is important and has to be assessed state by state.
Turning now to the next topic on our agenda, and I think this is the elephant in the room, given the wave of new case filings and the wave of large settlements recently, and that is litigation and litigation risk. Lou, can you give us a brief overview of some of the fundamentals of this litigation?
The TCPA is a very harsh statute in terms of its strict liability. Penalties are $500 per violation, with a treble damage provision leading violations to $1,500 per violation if you can show the conduct was willful, and there's no cap on damages. What does it mean to be willful? Well, if someone is on the do not call list and calls have been made to that individual, courts have held that that constitutes willful misconduct. We've seen and see very frequently complaints where the allegation is that 227 auto-dialed calls were made to one number over a 1 to 2 month period. Courts, generally speaking, have little problem seeing that conduct as willful. When an individual has a record of having requested that they be taken off of a call list, they've revoked consent. Even though the courts are in somewhat of a flux as to what constitutes adequate revocation, courts have very little problem saying that person asked you to stop, and again, it's the volume of calls. And in this day and age, we're in an era where because of the technology, you say, well, $500 per violation, you make a couple of calls to an individual. But this is really the situation, almost to a certain extent, run amok, in that you can dial thousands of calls in an hour. You can dial 10,000s, 100,000s of calls in a very short period of time using auto dialers, using the technology that's available now. Because those damages can very easily get trebled, and because there is no cap on damages under the TCPA, what you're seeing is liability, the creation of liability and potential liability, not only in the 6 figures, not only in the 7 figures, but in the 8 figures. And we have seen over the last several years, and even in the last less than 12 months alone, record-setting settlements in the TCPA area.
Let me make a couple of comments here. The no cap on damages is a big issue with this statute. Some other consumer statutes that have these $500 per violation provisions, for example, the Fair Debt Collection Practices Act, that statute has a $500,000 cap on damages. So regardless of what went on and how long it went on, you're capped out at $500,000. Now, $500 is a penalty. That's not spare change, but it's not crushing liability of the type that can arise under the TCPA. Another thing about the multipliers here is that it's easy to get into deep trouble very quickly because communications can be sent out very quickly, and there's we see that even the initiation of a campaign, even something that's only been going on for a few days can cause trouble. We assisted a life insurance company with a case recently where the problems had arisen only in the very first days of their marketing campaign, and they later got straightened out. Recent settlements, we've seen a number of big settlements recently, headline-making settlements. The current record is a settlement against Capital One just a couple of months ago, which was announced at $75 million. Also, within the last couple of months, we saw a life insurance company enter into a $23 million fax settlement regarding junk faxes and opt-outs.
Again, we just highlighted a number of more recent settlements, but for every one of these settlements, there are dozens more where the liability is in the 6 and 7 figures. We highlighted again, the 2013 and the 2014 cases just to give people a sense of the type of numbers that we're talking about now, which again relates back to the volume of calls that are being made. In the Capital One case at $75 million, that's an eye-popping number. And when you realize, though, that when you look at the number of calls that were actually made without the requisite consent, the potential liability, Wilson, I think in that case was upwards of $2.4 billion had that case been played out through litigation. We've got 2 questions that I want to take a brief digression and answer because they're relevant. One is, please expand upon the existing business relationship for outbound marketing calls, not via robo-dialer. Also, let us know what life companies are doing to communicate with brokers to educate them about TCPA. First, existing business relationship for purposes of making marketing calls does not satisfy the criteria. Existing business relationship gets to the issue of express consent but does not satisfy the criteria for express written consent. That was the significant change in October of 2013 when the FCC said, now to make marketing calls, you have to have express written consent, and the whole concept of existing business relationship plays no part in that rule. A number of entities petitioned the FCC to say, hey, tell us, does existing business relationship cut it? And to a large degree, the FCC did not respond. Again, what we've seen then is a number of lawsuits, a good number of lawsuits that were filed post-2013 based upon post-2013 communication where the company appeared to rely on existing business relationship when that was no longer the standard and no longer constituted the type of consent necessary for marketing calls. The second part of the question is, what are life companies doing to communicate with brokers to educate them on the TCPA? Again, there is no one-size-fits-all. There are seminars like this. We've helped companies prepare, kind of overviews of the TCPA, the do's and the don'ts. Frankly, the chart that we talked about earlier, the red, green, yellow, was an outgrowth of an education process that we went through with a company to help them educate their people. We wanted a very clear, concise do and don't sheet, and thought the traffic light was the best way to go. So there are any numbers of ways that people can help educate their brokers on the TCPA at the 10,000-foot level, getting down as granular as you want. Another question that has come up is how do companies go about, or plaintiffs' counsel go about finding class members? I could be snide, but I won't. It is a nightmare. What we have found in a number of cases is that one person will complain about conduct. In fact, we just resolved a case yesterday where one guy sent one fax, and the plaintiff's counsel filed the case as a putative class action. And what they were doing is they were fishing. Their premise was if one guy sent a fax, he must have sent other faxes, and if he sent other faxes, he must have sent them to multiple different people. If he didn't have consent in this case, he must not have consent in any case, and they go and they filed a putative class action. It turned out one guy sent one fax, and there really was no case there. But as people on the phone and on the webinar know, to say et al. And file your claim as a class action does not take very much more effort than simply filing a simple case.
I think that takes us into thinking about early stage case assessment, because on the flip side, we also see some of the more sophisticated plaintiffs' counsel. What they'll do is file a case as an individual case. It's very easy for them to find large numbers of plaintiffs. They can often reuse the same plaintiff once they have a relationship and that person gets another text message or another fax from some other potential defendant. And so a sophisticated plaintiff may file an individual case, but be thinking about that as if this individual case has some legs, I can turn this into a class action.
It's the Trojan horse, and we're seeing that more and more. What starts out as the individual case gets converted to the class case, and they're trolling, and they're trying to find out whether this conduct took place on a more mass scale than just on an individual scale. And when you're dealing with sophisticated companies that are communicating with customers, it's really not a far leap to say, again, whether you're a plaintiff's counsel or not, they must be doing this on a broader level. But again, it's what we are advising clients on is early stage assessment. Know what you're doing. Know what your company is doing. Know what your processes are, and know what your policies are. So we like to say the worst time to first ask the question is when you're holding the complaint. You've got to do your homework. The liability and potential liability in the TCPA area is so great that it's important that people take the time and understand how companies are communicating with their customers and prospective customers. If you're doing it by, and again, it's very commonplace to do it but using call centers, you have to understand the process they're using. Are you calling people who have given you consent? And if the consent has been provided, is it the right time of consent? Who are you calling? What are you calling them about? Where are you calling them? Home or cell? And how are you calling them? Are you using, do you have someone pushing buttons on a phone? Or are you using an auto dialer or a predictive dialer? It's the simple 5 W's that we all grow up asking.
Another key aspect of cases that I've got to read a message from our sponsors. For those of you who would like to receive CLE credit for today's webinar, the confirmation code is telemarketing in all capital letters. That's telemarketing in all caps. And you can use that code on the sign-in sheet available for download from your viewing console. Another key aspect of initial case assessment is to try to convince the plaintiff's counsel that this is not a potential class action for them, whether they've filed it as an individual case or whether they've thrown in the class allegations. If you can quickly get on top of the case, convince the plaintiff's counsel that it's not a case that's going to have legs for them, then if they have one plaintiff and one fax, their damages are, they're looking at a $500 case or maybe a $1,500 case, and that's the kind of case that can be settled on an individual basis early on without having to litigate something as a class action.
What we're finding is that the courts are more and more looking at the common issues of fact as being binomial. Were they called? Were they not called? Did they provide consent? Did they not provide consent? And that dovetails with a question that's just come in. Are companies just prohibiting or stopping using auto dialers? And in some case, the answer is yes. They're saying we're just not going to go the auto dialer route. We're going to manually dial the numbers because manually dialing the numbers takes you out of the TCPA realm. A manually dialed number to a cell phone or a landline, again, does not use automated pre-recorded voice, automated calls, and does create a safe harbor. So we are seeing companies going back to more traditional means of communication. It's slower, but it does remove a certain amount of the risk. Again, it also comes back to the issue, though, of if you are going to do it, it's important to know what type of consent do you need, and have you obtained that consent.
We have just a minute left, and Lou has segued nicely into some of our takeaways. Compliance issues. I think for companies looking at compliance issues, you've got to think about this up front. You need to have a plan for getting consent. You need to have the people involved know and understand the rules. We have gone over, in broad terms, some of the rules today, but there are nuances within all of these rules, and given that even a foot fault can sometimes spring into large potential exposure, this is an area where you really need to plan ahead. You don't want to have growing pains on your rollout because in this type of an area, things can, it doesn't take very long. A recent settlement involving a life insurance company was a seven-figure class settlement, involved text messages sent over 5 days. And so this is something where you want to be planning in advance. Third-party risk, we've talked about that throughout the presentation, knowing what your people are doing and knowing who they're contracting with to offer them services.
I owe a great debt to the person who asked the following question, what can companies do? And the answer is, in this one, you need experienced counsel. You need people that know the industry, that know the insurance industry, know your products, know your processes, and know your policies. You need counsel that's experienced with the TCPA. It's a very simple statute in terms of the do's and the don'ts, but it gets very complicated when you apply it to the issues of things like revocation of consent. And you need counsel with broad class action experience. Again, the potential liability in these cases, as we've seen, is not in the six figures. It involves a second comma. And once you're in the realm of the second comma of seven-figure, eight-figure potential liability, having that broad class action experience is important. Having the broad class action experience with specific experience in the TCPA with a knowledge of your insurance company business is critical to your successfully defending these types of cases.
We have taken questions throughout, and there were some questions we have not had a chance to get to today. We can get back to folks individually on some of those if we don't feel they were otherwise covered. Our contact information is attached here. At the bottom of the screen, www.sutherland.com/TCPA is a link to our practice website, and we have a number of different articles and materials on the TCPA that are available there, including a recent article we published on litigation issues facing insurance companies, and there's a more detailed discussion in that article about some of the cases and issues that we talked about here today.
And we will be sending out to all people who registered and attended today's seminar a copy of the slide deck. If there's any other information that people would like, if you'd like to follow up on any of these issues, again, please feel free to contact us. We hope that you'll take time to take a look at our TCPA website. You can download a copy of the red, green, yellow chart there, as well as access the other materials that we've put online. With that, on behalf of Wilson, Steve Roth, and our colleagues at Sutherland, Asbill, and Brennan, we thank you for your time and your attention today.